If you're a gun owner in Virginia, you need to stop what you're doing right now and pay very close attention to what I'm about to tell you. Because what started as a problematic piece of legislation has just turned into an absolute nightmare. Senate Bill 749 was already bad when it was first introduced as an assault weapon and magazine ban. But after it went through the Senate Committee on Courts of Justice, it came out completely rewritten. The changes they made transformed this from a bad law into something that could instantly criminalize millions of Virginians. We're talking about a single word change that shifts this bill from grandfathering your existing magazines to making every standard capacity magazine you currently own illegal contraband overnight. One word. That's all it took to fundamentally change the entire impact of this legislation. I'm going to break down exactly what Senate Bill 749 says, what changed in committee, why this change is so significant, and what constitutional challenges this bill is going to face if it becomes law. Because Virginia, you're about to be on the front lines of a major Second Amendment battle, and you need to understand what's at stake. Before we dive into Senate Bill 749 specifically, let me give you the bigger picture of what's happening in Virginia right now. There is an absolute mountain of gun control legislation moving through the Virginia legislature this session. We're not talking about one or two bills. We're talking about dozens of proposals aimed at restricting Second Amendment rights in the Commonwealth. Senate Bill 749 is just one piece of this larger assault on gun rights, but it's a particularly dangerous piece because of how it's evolved during the legislative process. What makes this even more concerning is that this bill had bipartisan support in committee, which means it has a realistic chance of passing. Virginia has always been seen as a relatively gun-friendly state, especially compared to states like California, New York, or Maryland. But what we're seeing right now is an aggressive push to transform Virginia into another anti-gun stronghold. If these bills pass, Virginia gun owners are going to find themselves in the same position as gun owners in the most restrictive states in the country. The Commonwealth is at a crossroads, and the decisions made in the next few weeks will determine the future of gun rights in Virginia for generations to come. Now, before we get into the specifics of the bill, I need to address some terminology, because this is important for understanding the full scope of what we're dealing with. When I use the term assault weapon in this video, I'm not endorsing that terminology. I'm using it because that's the term used in the legislation itself. I want to be very clear about something. This isn't just about AR-15s or AK-47s. Senate Bill 749's assault weapon ban includes semi-automatic pistols and several types of shotguns. This is a comprehensive ban on commonly owned firearms that millions of Americans use for self-defense, home defense, hunting, and sports shooting. When I talk about magazines, I'm referring to what the bill calls large capacity ammunition feeding devices. According to this legislation, the Constitution apparently protects magazines that hold 10 rounds or less. But once you get to that 11th round, suddenly it's no longer protected. This is what I call the magic bullet theory. Somehow, the Founding Fathers who wrote the Second Amendment when people owned cannons and warships decided that 10 rounds was the constitutional limit. 11 rounds? That's where they drew the line. It's absurd on its face, but that's the framework we're working with in this legislation. Keep that in mind as we go through the details, because the arbitrary nature of this limit is important to understanding why this law is unconstitutional. Senate Bill 749 was introduced on January 19th, 2025. In its original form, the section dealing with magazines stated the following. Any person who imports, sells, barters, or transfers a large capacity ammunition feeding device is guilty of a Class 1 misdemeanor. Now notice what's missing from that list: possession. The original version did not ban possession of magazines over 10 rounds. It only banned the commercial sale, import, barter, or transfer of new magazines going forward. This is similar to what Washington State did with their magazine ban. By not including possession in the prohibited conduct, you effectively grandfather all existing magazines. If you already own standard capacity magazines, you get to keep them. You just can't buy new ones or transfer the ones you have to someone else. It's still a bad law and still violates the Second Amendment, but at least it doesn't retroactively criminalize millions of gun owners for property they already legally own. That was the original version, and if that version had passed, Virginia gun owners would have faced restrictions on future purchases, but their existing collections would have been protected. They wouldn't wake up one morning to find that the magazines sitting in their safe had suddenly become illegal contraband, but that's not what happened. Senate Bill 749 went into the Senate Committee on Courts of Justice for review, and when it came out of that committee, it had been rewritten. The new version of the section dealing with magazines now reads, any person who imports, sells, barters, transfers purchases, or possesses a large capacity ammunition feeding device is guilty of a Class 1 misdemeanor. Did you catch the change? Let me highlight it for you. The committee added two words, purchases and possesses. That addition of the word possesses fundamentally transforms this bill. It's no longer just a ban on future commercial sales. It's now a ban on possession of magazines you already own. Think about what that means practically. every standard capacity magazine sitting in your safe right now, every magazine you bought legally last year, 5 years ago, 10 years ago, would instantly become illegal contraband the moment this bill is signed into law. You wouldn't be grandfathered in. You wouldn't get to keep what you already own. Everything you have that holds more than 10 rounds would have to be destroyed, rendered permanently inoperable, or surrendered to law enforcement. This is exactly the situation that California gun owners are facing in Duncan versus Bonta, the case currently pending before the Supreme Court. If I were a Virginia gun owner, I would be watching that case very carefully because the outcome of Duncan could directly impact how Virginia's law is challenged if this bill passes. Let me put this in personal terms so you understand the real-world impact of this law. Think about your own gun collection right now. How many magazines do you own that hold more than 10 rounds? If you own a Glock 17, the standard magazine holds 17 rounds. If you own an AR, 15 standard magazines hold 30 rounds. If you own any modern semi-automatic pistol or rifle, chances are the magazines it came with exceed this arbitrary 10-round limit. Now multiply that by the number of guns you own. Most responsible gun owners don't just have one magazine per firearm. You probably have multiple magazines for each gun. Maybe you have 3 or 4 magazines for your carry pistol. Maybe you have a dozen magazines for your AR-15. If you're like most gun owners, you probably have dozens of magazines in your collection that would be criminalized under this law. Some of you might have hundreds. Here's the critical part. Each magazine would be a separate criminal offense. This isn't one charge for violating the law. It's one class, one misdemeanor charge for every single magazine you possess. A Class 1 misdemeanor in Virginia carries a maximum penalty of 12 months in jail and a fine of up to $2,500. Now, would they actually prosecute every magazine as a separate charge? Maybe, maybe not. But the law as written allows for it. So if you have 20 magazines that violate this law, that's 20 separate criminal charges you could potentially face. The financial penalties alone could be devastating, not to mention the possibility of jail time and a criminal record that could affect your ability to own firearms in the future. Beyond the Second Amendment issues, which are obvious and significant, Senate Bill 749 in its current form raises a separate constitutional problem: the Fifth Amendment's prohibition on takings without just compensation. Let me read to you the relevant portion of the Fifth Amendment. Nor shall private property be taken for public use without just compensation. This is called the Takings Clause, and it's designed to prevent the government from confiscating private property without paying fair market value for it. Think about what Senate Bill 749 does. With the stroke of a pen, the governor would render your magazine collection completely worthless. You couldn't sell them because that would be illegal. You couldn't transfer them because that would be illegal. You couldn't even possess them because that would be illegal. Your only legal options would be to destroy them, render them permanently inoperable, or surrender them to law enforcement. In any of those scenarios, you receive nothing in return. The government has effectively taken your property without compensation. Is that constitutional? That's a question courts would have to decide, but there's a strong argument that forcing gun owners to destroy or surrender property that was legally acquired without providing any compensation violates the Fifth Amendment's Takings Clause. This creates an additional avenue for challenging this law beyond the Second Amendment arguments. The Supreme Court has generally held that regulatory takings where the government doesn't physically seize property but makes it worthless through regulation can violate the Takings Clause. The question is whether courts would apply that principle to firearms and magazines. This is uncharted territory in many ways, and how courts rule on this issue could have implications far beyond just Virginia. Of course, the primary constitutional challenge to Senate Bill 749 would be based on the Second Amendment, and there are several strong arguments against this law under current Second Amendment doctrine. First, there's the common use doctrine established in District of Columbia versus Heller. The Supreme Court held that the Second Amendment protects arms that are in common use for lawful purposes. Standard capacity magazines are unquestionably in common use. There are hundreds of millions of them in circulation across the United States. They're the default magazines that come with the vast majority of modern semi-automatic firearms. How can something that's standard equipment for the most popular firearms in America not be protected by the Second Amendment? Second, under the Bruin standard established in New York State Rifle and Pistol Association versus Bruin, the government has to demonstrate that magazine restrictions are consistent with the nation's historical tradition of firearm regulation. There is no historical tradition of limiting magazine capacity. Magazines didn't even exist during the founding era, and when they were developed, there were no capacity restrictions. The government cannot point to any founding era or Reconstruction era law that limited how many rounds a firearm could hold. Third, the dangerous and unusual test from Heller. The court said the Second Amendment doesn't protect dangerous and unusual weapons, but standard capacity magazines are neither dangerous nor unusual. They're standard equipment. They're ordinary. They're common. All of these doctrines support the argument that Senate Bill 749 violates the Second Amendment. If this law passes, you can expect immediate legal challenges based on these principles. The problem is that litigation takes time. It could be years before these cases are fully resolved, and in the meantime, Virginia gun owners would be living under an unconstitutional law, unable to possess property they legally acquired. Now, I know some of you are sitting there thinking, I'm just not going to comply. I'm going to keep my magazines regardless of what the law says. I understand that sentiment. I really do. Civil disobedience has a long and important history in America, but I want you to understand the risks you would be taking if you choose not to comply with this law. You are committing a crime. Multiple crimes, actually. One for each magazine you possess. While you might think law enforcement won't bother enforcing this, you can't count on that. All it takes is one traffic stop where the officer sees a magazine in your vehicle. All it takes is one home incident where police respond and see magazines in your house. All it takes is one disgruntled neighbor or ex-spouse reporting you to authorities. If you're charged and convicted, you're facing potential jail time, significant fines, and a criminal record. That criminal record could impact your ability to own firearms in the future, your employment opportunities, your professional licenses, and various other aspects of your life. I'm not telling you what to do. That's a decision every individual has to make for themselves based on their own conscience and their own risk tolerance. But I'm telling you to make that decision with full knowledge of the potential consequences. The better approach is to fight this law before it passes. Contact your state legislators, show up at committee hearings, make your voice heard. If it does pass, support the legal challenges that will inevitably be filed. Those challenges need funding and public support to be successful. So, what should Virginia gun owners be doing right now while this bill is still moving through the legislature? First, contact your state senator and delegate immediately. Tell them you oppose Senate Bill 749 and any other gun control measures being considered. Be polite but firm. Let them know this is a voting issue for you. Politicians respond to pressure, and if they hear from enough constituents, they will think twice about supporting legislation like this. Second, stay informed about the legislative process. Know when committee hearings are scheduled. Know when floor votes are happening. The more informed you are, the more effectively you can advocate. Third, show up. If you can attend committee hearings or rallies, do it. Legislators need to see that their constituents care about these issues. Empty hearing rooms send the message that nobody cares. A packed hearing room full of engaged citizens sends a very different message. Fourth, support Second Amendment organizations that are fighting these laws, whether it's the Virginia Citizens Defense League, Gun Owners of America, the Second Amendment Foundation, or other groups. They need resources to fight these battles. Legal challenges are expensive. Lobbying efforts take money. These organizations are on the front lines defending your rights, but they can't do it without support. Fifth, spread the word. Make sure other gun owners in Virginia know what's happening. A lot of people aren't paying attention to the legislature. They need to know what's at stake. Share information on social media. Talk to your friends at the gun range. Get the word out, because the more people who understand what's happening, the more pressure we can put on legislators to stop this. Finally, I want to zoom out and talk about what this means beyond just Virginia. If Senate Bill 749 passes in its current form, it will embolden anti-gun legislators in other states to pursue similar laws. They'll look at Virginia and say, if we can do it there, we can do it anywhere. If Virginia, a state with a strong gun culture and a history of respecting Second Amendment rights, can pass a comprehensive magazine and assault weapon ban with possession penalties, what does that say about the future of gun rights in America? This is bigger than just Virginia. This is about whether we're going to allow the incremental erosion of constitutional rights to continue unchecked. It's about whether we're going to stand up and fight for our rights or sit back and watch them disappear. Virginia gun owners, you're on the front lines of this battle right now. What happens in your state legislature over the next few weeks will have implications far beyond your borders. Other states are watching. Anti-gun groups are watching. Gun rights organizations are watching. The outcome in Virginia will influence legislation in other states. It will influence court challenges. It will shape the national conversation about gun rights for years to come. Senate Bill 749 went from bad to worse with a simple committee rewrite. What started as a future sales ban became a retroactive possession ban that would criminalize millions of law-abiding Virginians overnight. This is exactly the kind of constitutional overreach that the Second Amendment was designed to prevent, and it's exactly the kind of law that needs to be challenged and defeated. If you're in Virginia now is the time to act. Contact your legislators. Show up to hearings. Make your voice heard. Your rights are on the line. The time for complacency is over. The time for action is now. I'll be tracking this bill and others as they move through the Virginia legislature. Make sure you're subscribed so you don't miss updates as this situation develops. If you found this breakdown helpful, hit that like button. Drop a comment with your thoughts, and share this video with other Virginia gun owners who need to know what's happening. The fight for the Second Amendment is ongoing, and it requires constant vigilance. This nation was built by armed scholars, and this nation will be maintained by armed scholars. Stay informed, stay engaged, and most importantly, stay armed and stay legal.